Marco Botta, Simonetta Vezzoso, Mikolaj Barczentewicz, thank you very much for joining this discussion within the Digital Markets Research Hub. Very warm welcome. We have the first two non-compliance decisions under the DMA. The regime just emerged and it evolves quite quickly. You've been dealing with the issues related to competition law and data, let's say, management, not necessarily protection, for a long time. You are known opinion makers and you have quite different normative positions as well. So it would be difficult to find a better composed panel for me, and I'm grateful for your availability. So without further ado, let us revert to just the basic outline of the problem, which according to the DMA enforcement, to the DMA team, exists with matter compliant or non-compliant rather with the DMA obligations. Perhaps let us start with you, Marco.
Hello, Alistair. Very happy to be here. I think you all know Meta, let's say. It's probably the company that controls the largest social networks in Europe, Facebook and Instagram, I think, in terms of number of users. Its business model, it's very well known, is based on target advertising. Meta collects a huge amount of personal data within its ecosystem and also from third parties, cookies from websites, for instance. And these data are then processed and combined and help Meta to personalize its ads. So under the DMA, Meta, the Commission designated Meta as gatekeeper back in September 2023 in relation to its social networks, Facebook and Instagram. And a few months later, November 2023, Meta launched in Europe a new version of Facebook and Instagram. So essentially, user could benefit from an ads-free version of these two social networks if they paid a monthly fee. If I'm not mistaken, it was approximately 13 euros for iOS users and 8 euros for Android users. And users essentially could decide either to continue with the free version of Facebook and Instagram subject to ads, to target advertising, or to pay this fee and to get an ads-free version of Facebook and Instagram. And then very recently, at the end of April 2025, the Commission imposed a fine, 200 million euro fine on Meta for lack of compliance with Article 5.2 of the Digital Market Act. As you said, always before, this is one of the first two non-compliance decisions under the DMA. And what is Article 5.2? Essentially, it prohibits gatekeepers like Meta from combining and cross-using end users' data collected from different sources within its own ecosystem. So essentially, Meta as a gatekeeper could not combine the data collected from Facebook and Instagram and all the other services, of course, that it has within the ecosystem in order to further personalize its services and engage in target advertising. But, and this is, I think, the point that creates a lot of debate and dispute in front of the Commission, Article 5.2 provides for an exception. So if the end users are offer a specific choice from the side of the gatekeeper, let's say, and if the end user provides his, her consent in compliance with the GDPR requirements under Article 4 and 7 of the GDPR, then let's say the end users can authorize the gatekeeper from continuing, let's say, this data combination. So why did Meta introduce this new model that is known as consent versus pay? My understanding is that they did it after the ruling of the European Court of Justice in the German Meta platforms back in July 2023. There is one paragraph, paragraph 150 in the ruling, where essentially the courts say platforms like Meta should provide to end users two types of services, one free of charge, subject to advertising, another one equivalent, but without data processing operations. And the code say, if necessary, the platform could charge an appropriate fee. And I think we will debate what it means, this appropriate fee. So the origins, let's say, of the consensus to pay model launched by Meta are, in my view, in this ruling on how you can interpret this paragraph 150 of the German Meta platform. Then in April 2024, so over 1 year ago, the European Data Protection Board issued an opinion on the consensus to pay model. The opinion is based on the GDPR, not on the DMA. Essentially, here the board interpreted this paragraph 150 of the ruling of the European Court of Justice, saying if users have only a binary choice, they will never opt to pay for a service that in the past they were getting for free, and therefore they don't provide a free consent, a real free consent. They are not really free. So this does not comply with the requirement of Article 7 of the GDPR. So the consent is not valid, let's say. And this opinion is very important. I think we will further talk about that because the Commission, in its infringement decision in April, essentially relies on the EDP opinion extensively to say that the way in which Meta aim at complying with Article 5, Paragraph 2, was not okay because there was no specific choice and because the consent was not valid in light of the opinion provided by the EDPB over 1 year ago. So this is where we stand at the moment. In the meantime, Meta has changed its business model further. It has, first of all, lower its fees. In Europe, now I think it's 10 euros for iOS and 6 euros for Android devices. And I think what is very important is that it introduced a third option, which is the so-called eighth breaks. So when you access Facebook or Instagram page, then you can select as an option that you are not subject to target advertising, but you need, let's say, to break the browsing of your of the feeds that you have, so that essentially you focus your attention for a couple of seconds on a specific ad, let's say. So this is, let's say, a third option that has just been introduced recently. I think it was November last year by Meta. But what is very important is that the Commission decision that we are discussing today, the decision adopted in April 2025, only refers to the period between March and November 2024. So for 8 months period, March 2024, it's when Meta started to comply with the DMA, let's say, obligation, including Article 5.2, and November 2024, it's when Meta changes business model, lowering the monthly fee and introducing the ad break. And the decision, the Commission does not take any clear position on whether the new model introduced by Meta complies or not with Article 5.2. So this is still something open and something that we can now discuss. So this is a summary of, I think, the decision. I don't know if Simonetta and Mikolaj wants to add anything.
Please, Simonetta.
No, thank you. I mean, it was great, Marco. Thank you so much. Thank you so much, Oliver, for the invitation. I think you provided a very nice summary. Perhaps just, focus on this decision. Yes, perfect. I would have perhaps also given an overview a little bit broader about Article 5.2 to place it, because, I mean, this decision is just about combining data from Facebook or Instagram with data from meta ads. Okay, so many other types of cocktails combinations are not object of this decision, but I think it's increasingly important going forward when we think, of course, of what's happening in the AI space. And not only that, but these are all perhaps, for instance, Instagram and Threads combining data. What about providing, in that case, a choice to consumers who don't want to consent into this type of combination? So it's a little bit broader. So we are talking, discussing here a very specific aspect of Article 5.2.
Thank you very much, Simonetta. Mikolaj?
Thank you for the invitation, Oles. And I really don't have too much to add to Marco's introduction. I think the key points from me are the obvious ones, but I think it may be worth restating for our audience so that the substance of the non-compliance finding was based on two pillars. So the first one was sort of lack of freely given consent, and the failure to provide a less personalized but equivalent alternative, which the Commission says is a requirement under the DMA. And perhaps one other sort of pillar or an aspect of this, which is also worth noting, is that the Commission said that if Meta offers its services, Facebook and Instagram, for free, the equivalent alternative must also be provided free of charge. So I think that's the core of that non-compliance finding.
Thank you very much. Let me now then combine two questions in one, giving you a chance somehow to select, because we risk that next question will be again answered. Okay, so two questions, connected but yet rather different. We know that we can enforce the DMA mechanistically, first come, first served, in a kind of syllogistic way, identifying potential non-compliance, investigating, and then establishing. But probably one would expect having some kind of broader meta goal of selecting cases. So what is the end point in investigating this instance of non-compliance? Is it about new entrants? Is it about vertical improving a situation for business users? Is it about advertising? Is it about end users? So this is the first question. And the second question, we are witnessing somehow paper, rock, scissor game where we simultaneously have several regimes without clear-cut, self-evident primacy of one over the other. So how do we settle which of these 3 or 4 regimes regulating similar, very similar issues have precedence over others? Marco.
Thank you, Oles. These are very interesting questions. I think we can talk for hours about them because they are very broad. So let me start about the goals. So we know that the DMA has 2 goals. So to foster fairness and contestability in digital markets. If we look at the DMA preamble, paragraph 32 and 33, contestability essentially is defined as the ability of undertakings to overcome entry barriers to challenge the gatekeeper and entrenched market power. While when it comes to fairness, it's the relationship, essentially the relationship between the gatekeeper and the business user. I think what is very important is that the objectives of the DMA are not to improve the fairness of the relationship between consumers and users and the platform, but business users like developers that rely on the gatekeeper platforms. So I think I will start from here. And if I look at Article 5.2, I think my view, Article 5.2, it's essentially about contestability, to foster contestability. So gatekeepers are large platforms that provide multiple services that have a very large number of users, about 40 million, 45 million. So they are those ones which have the capacity to profile users, to collect personal data from so many different sources and to combine them together. So that is one of the main competitive advantage of gatekeepers in comparison to non-gatekeeper platforms. So Article 5.2 essentially limits one of the competitive advantage of the gatekeepers in order to foster contestability. What type of contestability? Essentially, we are talking about potential entry in the market of other competitors of the gatekeeper, like in this case, a new social service enters in the market, contesting the market position of Facebook and Instagram, while because it still can engage in data combination, and therefore it can further personalize ads and services delivered to final users. This is my view, at least. Then when it comes to the second question, so this bit theoretical, I think it goes beyond the scope of the discussion today. I can tell you what my view, especially when it comes to the relationship between the GDPR and the DMA, which is, let's say, very important for Article 5.2, I would say. So let's say GDPR and the DMA are both regulations, secondary legislation. They have the same status in the hierarchy of legal norms. Let's say they are not treaty provisions. If we look at the DMA preamble, it's written that the DMA applies without prejudice to the GDPR, but it's not explained what without prejudice means. If we compare the DMA with other legislation, I'm thinking about the Data Act and the Data Governance Act, there is a clear difference. So in this later legislation, it's clearly mentioned in the preamble that in case of conflict between this legislation and the GDPR prevails, while this is not mentioned in the DMA. And I think, and I wrote about that in the past, that the GDPR and the DMA have different objectives, fairness and contestability versus, let's say, protecting the privacy and personal data of individuals. And overall, my view is that the DMA regulates a more specific subject than the GDPR. It's applicable only to the gatekeepers, not horizontally applicable to, let's say, all the forms of data processing, let's say. And my view is that essentially the DMA, it's a lex specialis in comparison to the GDPR. So let's say in case of conflict between the two, we would follow, let's say, the DMA when it comes to regulating the position of the gatekeeper. I think this is also implicitly the position followed by the Commission in the meta decision, because the Commission emphasized in the decision that under Article 5.2, there are two conditions to be met to allow data combinations: offer a specific choice and, let's say, to ask for consent from the users. While Meta argues that the two are connected together, let's say, that they are not separate conditions. And the Commission say, no, these are separate conditions, and specific choice, it's a new condition that does not exist under the GDPR and should be interpreted in the light of the DMA objectives, so in the light of the contestability goals at the basis of the DMA.
Thank you very much, Marco. Simonetta.
Yes, again, Marco said it all. So I agree with many of the things he said. I would just add a couple of reflections, perhaps. First of all, I think this decision and this provision of the DMA is basically about giving choice, something that Marco also said. It's about giving choice to users, so strengthening to some extent the choice already provided to users under the GDPR, but strengthening it. So in this sense, it's also about fairness. It's not just about contestability, it's also about fairness in this respect. And then I think it's about sort of trying out new things, like, for instance, a social network which can thrive, not only based on targeted advertising, but in a different based on a different advertising model. So in this sense, it provides choice and provides a sort of contestability among different business models. And so behind the different services we're dealing with. So I think this is an important aspect. And also in terms of private enforcement of the DMA, I think it's very important for users to realize they have this right provided by the DMA, which is pretty clear. The decision by the Commission is pretty long, but it's possibly not because the legal questions were that complex. It's because, of course, Meta quite correctly used the whole arsenal of legal arguments and also economic arguments to do that. But of course, it's perfectly in its right. But from the point of view of the language of the DMA, I think it's really pretty clear. And I think it provides good tools to end users also to exercise their rights in the digital economy, beyond what the GDPR provides, beyond what antitrust competition policy is has been able to provide them so far. And then about the idea of contestability, of course, here the directly involved core platform services are social networking on the one side and advertising, online advertising. And of course, one of the questions is about, but based on the DMA, are these services going to be really contestable? And of course, we cannot look and answer this question only looking at Article 5.2. So the DMA has a lot of different provisions. They apply holistically. The DMA evolves. We are already under review of the DMA. So somehow, of course, we can say, does it work? Is Article 5.2 there, and somehow it fulfills its objectives? But the other question would be the broader one: do we need more to really ensure contestability of social networking and online advertising services? So I think there are two different questions. And about hierarchy of different sources of legal provisions, well, what I really hope for is that we will definitely have also in that respect a holistic enforcement. On the one side of the GDPR, DMA, and then increasingly think of the AI Act, think of the Data Act. So this is the future. This is something it's very important. Of course, we have a mechanism within the Digital Markets Act, which is the high-level group. So they are really collaborating, but I'm really looking forward to seeing the guidelines that the protection authorities together with the Commission has been promising us for a while about how the GDPR interacts with the DMA. And I think, so it's, to me, it's not so much a hierarchy of the different sources or about, yes, what happens in case of conflict. Yes, but these things have to be sort of worked out together, first of all, by the different regulators and, of course, by judges down the line.
Thank you very much, Simonetta. Mikolaj?
On my reading of the decision, it seems to me that the Commission, even though they start by noting that the DMA has those dual goals of contestability and fairness, this decision seems to be leaning more on the contestability side. And when I read, for example, paragraph 5, I look at how much the Commission stresses the point of barriers to entry. That in their assessment, the scale of data processing that Meta is able to do, that this scale creates a barrier to entry for other undertakings. And to me, this raises a very interesting question. Okay, so because the Commission doesn't really talk about what is their vision of what they want to achieve through this enforcement action. They only say, okay, there are those barriers to entry for other undertakings. But so if we look at it, it really seems like they talk about barriers to entry in the market for the provision of advertising, right? So selling ads, perhaps as an intermediary, given that Meta Ads was selected and designated as a separate service from front-end services that users directly interact with. So we have meta ads as an advertising backend, and it looks like the issue here the commission notices is that there should be more contestability for potential competitors for meta ads, and so that's one issue, because there is also this issue of improving the situation of business users, because who are the business users in this situation? So we're really talking about the business users of meta ads. So again, advertisers, small, medium, large companies, enterprises that use meta ads to currently target Facebook and Instagram users through this advertising backend. So I guess the idea must be somehow implicitly that the situation of those business users, advertisers, can somehow be improved by sort of restricting the cross-use combination of data that the Commission says created barriers to entry in the market in which meta ads operates. And here is one problem that I have with the decision, which is that there are some effects which are potentially quite immediate for those business users, and those effects also, I think, follow from what the Commission quite astutely noticed. And the Commission, making their case about how big the market power of Meta is, they make this observation that Meta and Meta ads is a great tool for advertisers. And it's a great tool for advertisers because it has the scale in terms of how many users you can reach through those through meta ads, but also in terms of the kind of personalization that is available to enterprises, which is especially important for smaller advertisers. I mean, if you're L'Oréal or someone, you can do so-called brand advertising. So you can use billboards and you're just trying to create market awareness. But if you're a niche artisanal manufacturer of some sort of an accessory, I don't know, like well, whatever, for computers, baby accessories, things. If you want to target your market, which is not your local market, then you don't have the budget to just buy billboards like L'Oréal to increase brand advertising. You really need to reach specific customers, right? And here is where personalization becomes existential to you. So the Commission says, well, Meta has been amazing. And that's a problem because it's so good that it's hard for anyone to compete with them. And now the question is, so when we have this decision that will restrict, or is aiming to restrict, and I guess hoping that it will lead to a situation where there is less data that users consent to for Meta to use. So that seems like leading in a direction of making Meta ads worse for its business users, right? So creating contestability by thwarting kind of that gatekeeper. And so that's a clear effect. So we have, as the Commission says, many business users which are now benefiting from the service, are happy with it. The Commission kind of aims to make it worse for them, so they will be negatively affected by this. And then there is an implicit hope. The Commission really doesn't discuss this, but there must be some sort of an implicit hope for a later effect that somehow, through the operation of what Simonetta mentioned, the interoperability provisions, and so on, and Article 5.2, that, well, I somewhat perhaps cynically I would say magically there will be a new player in the advertising ecosystem who will somehow offer a better product to those business users, and hence contestability will improve the situation of those business users. But yes, but I see two problems with that ever happening. So first, there is the issue of scale. So it would have to be the case that somehow Meta would also want to play with this other advertising backend, which I'm not sure anything in the DMA forces them to be a forced purchaser for a new advertising backend. And the other issue is that due to the GDPR, there may be very significant barriers for any new, especially big player, someone who would be attractive to the business users, to actually reach sufficient scale and offer sufficient personalization so that we are at least Pareto optimal as a result of this intervention, and hopefully better off. So I'm skeptical that the Commission has a vision how this would happen. I think they are just hoping that we apply the DMA. We don't actually really care. Our job is to apply the DMA as we interpret it, and then it's the legislator's fault if it goes wrong.
Let me pause here and just make a note that you are invited to ask each other and comment on each other's interventions. And I wanted to ask you very quickly, do you think that it's within the mandate of the DMA to have this, to expect for the DMA team to have this broader strategic vision for tailoring competition, improving competition, maybe designing competition in digital markets, or it would be ultra virus and the enforcement team will just say there is an obligation, there is an instance of non-compliance, it appears to be, our job is limited to just bringing justice or following the prescription of the regulation. Mikolaj, probably this is to you because
okay,
that's
I'm happy. I'm happy to address this one, but I'm sure others will have thoughts as well. So I think it's quite clear to me that the Commission's view is. I hope they don't hate me for saying it, but it's the kind of a Pontius Pilate perspective. We can wash our hands of any economic effects of what we do, but I think that may be too quick, even based on the DMA, because it seems to me that when you engage in the interpretation of what the DMA requires, because as we've seen through the DMA workshops and the long exchanges between the Commission and the companies, the DMA is much less clear and self-enforcing than it was advertised during the legislative process. So when it comes to the interpretation of such provisions like Article 5.2, and for example, whether there's this issue, what does as the Commission says, what does specific choice require, and so on, or Recital 36, which I'm sure we will talk about, I can't see how you can interpret those provisions without having a vision of an effect and of what is the teleological interpretation of that act. And I think in this the Commission is failing, I'm afraid. I think there's very little engagement with this idea of what is this all for, beyond just repeating it's for fairness and contestability. But what I just mentioned, which I think is pretty basic economics in terms of effects on business users, you will not find that at all in the decision.
Simonetta.
Okay, thank you. So, well, first of all, about the economics of the DMA. Of course, the economics have been much in the background. That's the reason why we have the DMA, because of the reasons that gatekeepers can have in achieving all their power is also based on data combination. So it's about now creating data silos, and it's about recreating the choice, taking into consideration, as the Commission does, that, I mean, it's not textbook economics in terms of industrial organization economics. It has to do with behavioral biases, and those are taken much into consideration in the decision. So it's really about economics. And about economics doesn't mean just to think about, okay, targeted advertising is great, we should make it more targeted. Okay, because it's not the type of innovation that we are looking forward in our EU. Of course, we want to have advertising supporting those services, but the choice that the DMA provides is of trying out different models of advertising. If it had been my choice, I would have prohibited many types of data combinations, okay? Because I was really afraid of the fact that, of course, choice would have not been possible, because then the gatekeepers would have found way to lure users into consent. I'm very happy that the Commission takes the wording of Article 5.2 very seriously, that it's not so easy to use all the tricks we are used to also under the GDPR in the case of gatekeepers. So it's about really creating choice to create alternatives, but those alternatives is not just about we love targeted advertising, we need more, okay? Because this is not, I think, a good, I mean, it's definitely not the direction the legislator wanted the Commission to go when enforcing the DMA. But based on that, of course, we cannot just think magically that now, because of innovation, new space for new social networks or different, I don't know, advertising services, that everything will be fine forever. Not at all, because of what we are seeing is that even though the DMA is creating some choice, we are not seeing so many alternative services emerging. So definitely, I would be totally with Draghi on that we need perhaps to think also on supporting a little bit of things which are of importance to us, like digital autonomy, creating new services. So it should be a sort of accompanying the DMA. Okay, the DMA is not sort of magically making all our problems disappear. Not at all. But it's an important tool. And again, I think it's very, very important that if goes the way that Commission wants the provision to be enforced by Meta, that Meta users, with quite a lot of people, so if you consider them all, they start understanding they can choose. It's not that if they want to have a social network, even though perhaps they don't like targeted advertising, they should say, well, it's the only way things can go. Not at all. They have the possibility of choosing a less personalized experience. Okay, they should be equivalent. It's totally doable. If Meta is able to demonstrate that it's not doable, that's the umbrella of the Meta ruling. Otherwise, totally doable. And it's a choice that things that consumers have, business users have, because even the small hairdresser in Rome looking for new customers could start doing advertising based on, not only on target advertising, based on how the user interacts with the platform. So data collected by Meta on the Facebook service, okay? And that could be used to say, okay, look, so there is this offer in my shop or whatever. So it's not that the only way for small businesses to thrive is because of targeted advertising. Thank you.
Thank you very much, Simonetta. Okay, so we have kind of two positions. One is kind of punitive, contestability related, that we need more competition on this horizontal or newcomers on the horizontal market, and thus we take a big backpack, put a lot of sand there, and take the front and say the front runner, you can run as fast as you can, but now your capacity will be slowed down. And the second one is, well, you are kind of abusing your dominance and exploiting your business users and end users, depending on where you stand. And thus, there is an optimal solution to this. You just don't play by the rules, and let us try to calibrate the rules. So I just wanted to maybe to invite you to reflect upon what does the Commission, is it clear from the decision, non-compliance decision, what the Commission wants, would expect Meta to how the compliance would look like from the perspective of the DMA team? Marco.
To be very honest, it's not. Why it's not? Because the decision was adopted in April this year. It refers to conducts by Meta between March and November 2024. Meta, in the meantime, has changed, let's say, its business model, as I said at the beginning, but there is no assessment of the aids break, of the impact of lowering, let's say, the fees. My view of the Commission decision is that it looks very much like the typical antitrust decisions, where the Commission adopts an infringement decision, including a cease and desist order. So stop self-preferencing your services, stop bundling Google Chrome to Android, plus a fine. Okay, but this is fine for antitrust, where you have ex post enforcement. This is regulation. Okay, it works ex ante. So the companies, it's not about fining companies. It's more about establishing a regulatory dialogue with them to make clear what they can and they cannot do. Okay, so the fact that the Commission adopted a decision so late in relation to past events and the business model of Meta has changed in the meantime, and the Commission has not clarified whether the new approach is fine or not with Article 5.2, creates, in my opinion, a lot of legal uncertainty, let's say, not only for Meta, but also for other gatekeepers that, as I said before, it's Article 5.2, it's an horizontal provision that is applicable to all the designated gatekeepers under the DMA.
Thank you. Who would like to first, maybe Mikolaj and then Simonetta, yeah, just to keep the order.
Okay, sure. So, as Marco said, there is little of that, and it's partially because of the scope of the decision, but there is a little bit towards the end of the decision where the Commission also reserves the option to impose daily monetary penalties, which, correct me if I'm wrong, I think it's up to 5% of a daily turnover of the gatekeeper. So, and in that discussion, they talk a bit in a very non-committal language about what they think of the current choice flow that Meta has, and there is really only one comment they make that they are unhappy with, which is that it used to be, Meta already changed that there was a 1, 2, or 3 screens, and in one of the screens the option for users who chose not to pay, the option to keep the current sort of standard Meta level of advertising and personalization, it was pre-selected. And if users hid that pop-up, this was the default. So it was the default, it was both pre-selected, and if a user did not make a choice beyond paying, not paying, that was also the default. So the Commission said they don't like that, but Meta already changed that. Meta changed it, I think, the day before, which was the deadline set by the Commission, and we know very little of the Commission's thinking about this, but there was a report from Reuters which suggested, and there was a statement by the Commission's press representative saying that Meta made only limited changes and they are still assessing. And then Reuters reporting saying that it's unclear who talked to Reuters, whether Meta or the Commission, but saying that it looks like that Meta will not budge, that the changes they made, which was the only thing that the Commission mentioned and some other things, that's according to Meta, that's enough. And the Commission says that's not enough, but it's unclear whether even Meta was told by the Commission what else is required. So it's a bit of an unclear situation. So yes, the vision of the effect of that remedy seems to be also moving in terms of the goalpost. It does look like the Commission is shifting the goalposts. So we'll see. I wonder if Meta will decide to go for what I would call a nuclear option and try to just dismantle Meta ads in such a way as to create Facebook ads and Instagram ads, that so backends that would be tied just to those services without any sharing between Facebook and Instagram, and then to benefit from something that I think Recital 36 DMA says, where you have a service which is in a support of another service, then they are not treated as cross-use of data, even though they kind of look like different services, which is what the Commission accepted for TikTok explicitly. So perhaps Meta has that option. If they decide that this conversation about 5.2 is just too difficult, they can't reach a conclusion, they might actually be able to avoid 5.2 entirely by not having a separate ads CPS, but integrating ads into Facebook. So I wonder if they maybe to go that direction.
Mikolaj, Simonetta?
Yes, I agree with Mikolaj that Meta knows no boundaries in fantasy when it's about what we have seen not complying with the GDPR. Okay, so I'm afraid the same could happen with the DMA as well. So I see consent or pay model as a clear attempt to establish a precedent in this direction. So finding a way of gaming the DMA as they have been gaming the GDPR for many, many years. And so this is, I totally agree with Mikolaj on that. And also I agree that, for instance, I mean, we are free academics. We don't know much about what's going on in terms of a relationship between the commission and the gatekeepers, because, I mean, we could also, I would say, provide some important feedback on whatever. So this is a problem with the DMA. For instance, under the DSA, researchers can access data and then can provide some useful feedback to the regulator. This is not the case with the DMA. And this is a problem. This is definitely a problem. That's why also I think that those public compliance workshops are not very useful in the sense that, I mean, how can you judge when things are going in the right direction if you don't have access to the data? Okay, so the commission has access to the data, the gatekeeper has access to the data. What about third parties? What about researchers? We don't have access to data. This is a clear deficit of the DMA. We tried to flesh it, we tried to highlight it during negotiations. Nothing was done. This is a problem. Concerning whether the commission has given enough indication to Meta, of course, we don't know. What I can only say is that Meta has been presenting this version of the consent or pay model already in November 2023 to the commission. Okay, so I imagine there have been plenty of exchanges of all possible shapes, colors, etc. And also requests for information, also with regard to third parties, etc., etc. So I don't think that Meta is really in the dark about what they are supposed to do. Well, neutral choice. Of course, what does it mean, neutral choice, with regard to the combination of personal data for us? There, of course, you need also technologies. It's about the design of the choice screen. So it's about, of course, you have very good technologies on the side of Meta, you have very good technologies on the side of the enforcers, but it should be the end user should be presented with a neutral choice. And this is something that, of course, is still under discussion, what it means. But I don't think Meta doesn't know what the neutral choice means. And also, what does it mean in terms of equivalent? I mean, also that is not, I mean, it's not impossible to figure out. And I think the commission has been indicating many, many times what it means equivalent and what it means equivalent in terms of user experience, performance, condition of access. I don't think it's that terribly complicated. Of course, if Meta doesn't want to comply because, for instance, of course, it wants to hear. It's totally in its right to hear what judges think, for instance, of that. There are those 6 words in the Meta ruling. Great, do it. Okay, it's in your right. But I don't think, I mean, from my perspective as a researcher, looking at it and looking at how things develop, that Meta doesn't know how a compliance solution should look like.
Okay, then let us move now. Once we somehow maybe not agreed, but at least significant arguments have been raised that the DMA allows the commission to accelerate and to slow down dependent, so it gives this generous toolbox and to focus on specific instances of non-compliance in more detail. And this is not a bug. For some it's a bug, for others it's just a natural feature to bring more equilibrium to this otherwise huge asymmetry of competences and information, depending on our normative position. But in the same way, we can say that gatekeepers have this omnipotent ability to comply with everything, and knowing all the behavioral patterns and knowing how to do reverse or any engineering of choice. Why is it so problematic for Meta to say to the commission, tell us what you want, we will we will fine-tune our system accordingly. Is it from the purely factual perspective, in your view, is it so difficult? Is it a matter of principle, or they just don't know how to comply? Then they're genuinely being somehow targeted by the enforcers, Marco?
I think it's a mix of both. I would say on the one hand, I think I agree with what Simonetta is saying. I mean, there's been a lot of interaction between Meta and the Commission since they plan to release the consent versus pay model, let's say. I read in the decision that this was announced by Meta to the Commission in September 2023, so that was 2 months before releasing that on the market. It's not very clear, on the other hand, from the Commission decision, if really the Commission gave a feedback to Meta that the consent versus pay model was not okay with Article 5.2. For instance, I find a bit problematic the fact that the EDPB adopted the opinion that is relied then by the Commission in the Meta decision only 2 months later after the entry into force of the DMA obligation. So we are talking about April 2024, end of April, while the DMA obligation entered into force for Meta and the other gatekeeper, the first designated gatekeepers, beginning of March 2024. So I think, let's say, both sides have some points, I would say. No, so there has been a lot of interaction between the parties. It's true. I don't know to what extent, because I was not involved in these negotiations, whether the Commission was very clear and saying, look, you are on the wrong track. And this was not, I think, done before Meta released the new consent versus pay model on the market. This should have been done before. And I think this is part of the idea of this regulatory dialogue, which should guide the DMA enforcement, which is very different in comparison to antitrust enforcement. As I said before, it's not about fining the gatekeepers, it's to find a way, let's say, to make them comply with the DMA obligation. And I think the Commission still has to work on that.
Thank you, Marco. Mikolaj?
Is it so easy for Meta to say what the Commission thinks or will think in 2 months? I don't know. I'm not part of those conversations, but I'm trying to do some amateur criminology about what the Commission is trying to think, especially, so as I said, we have this one paragraph in the decision, and then reporting that the Commission is still unhappy with Meta doing what the Commission said in that one paragraph. So what could the Commission want more? Perhaps we can imagine sort of a maximalist interpretation that what they actually want is something like to actually combine the GDPR and DMA choices, even though they think they are separate, into sort of a triple choice, where the default is that option where users do not pay and they get less personalized advertising. And perhaps because what happens in that option is that you also have, for example, non-skippable ads. I think Meta representative during the DMA workshop recently said that currently it tends to happen like once per day to a user, but you can imagine that it could start happening more often. And why could it start happening more often? Well, if that becomes the default and users start choosing it, it could become sort of existential in an economic sense to Meta to fund the provision of that service, that they recover their costs this way, right? And because we know that contextual advertising doesn't work for SMEs, and it's much less performative, sort of performs much worse than personalized advertising. So there could be an issue for Meta that they would need to somehow do something with that option to recover more. And then the Commission says, well, but this actually goes what we think is necessary, what stems only from the fact that you're not allowed to personalize. So actually, you need to offer the current experience with ads that look like they look today in personalized ads for free as a default. And that is most likely just economically not viable to Meta. So Meta can probably guess that that this is like an ideal situation the commission may want, but that's probably not economically viable. And of course, the commission says has an answer to that, which says that they don't care about economic consequences on gatekeepers unless there is an application made by a gatekeeper pursuant to Article 9(1) of the DMA, where the gatekeeper argues that I forget the exact phrasing, but that the basic economic viability of their operations in the European Union is threatened, and they make a special application, and only then will the commission take that into account. So it kind of looks like the commission wants it this way, that first they want to lead to a situation which Meta probably thinks is utterly non-viable, and then the commission says, okay, then you make that other application, and then we have a conversation about that. So that's my guess what could be the issue here.
Thank you very much. Simonetta, is it a whack-a-mole both from the commission perspective but also from the gatekeeper's perspective?
Well, yes, it's part of this type of regulatory dialogue also under Article 5, not only under Article 6. Under 6 is little because, of course, at some point you can come up with specification decisions, which are very helpful. But I think, I mean, first of all, I think I said it already before. I think there have been indications enough, and it's, of course, something which is going to be decided not only, but mostly perhaps now based on technological solutions. Okay, I think the legal principles are pretty clear, the economics are pretty clear. It's about now about how you present choice, the data that you collect with the different experiments that you make, the data that you share, and those are things about choice architectures, interfaces, and things like that. So this is going to be key, and I think it's going to be also very important for the commission in terms also of gaining experience. I mean, it's also a regulator who is learning in that respect. And so involving technologies in that with regard to that type of decision, which is legal, economic in the end, and also technological, is going to be key. So I think this is a very important direction that the DMA is going, and it's unavoidable for the time being. I think with time, okay, we will know basically much better than now, of course, because many aspects have been litigated based on the first decision, exactly what the correct reading of the DMA will be. But I think it's nothing new. I mean, it's a new piece of legislation. It takes time. There will be also things added, changed, iterated. I mean, I think it's really part of the DNA of the DMA to some aspect. So we shouldn't be now astonished or anything like that. And I think actually that the commission tries not to be too prescriptive on the one hand. On the other side, it's for the gatekeepers to demonstrate compliance. This is also key in the DMA architecture.
Okay, so before inviting you to provide recommendations to students and maybe to raise any other issue which we have, important issue which we have omitted, obviously we have omitted many. I wanted to ask your opinion about, from the very beginning we knew that this non-compliance case concerns the behavior of the past, as you explained very clearly, Marco. But we have now 2025, we have non-confidential version of compliance report, we have these public compliance workshops. What is your opinion about the relationship with Meta and the overall atmosphere within this Meta ecosystem and the DMA? Is it an autonomous part? Is this specific non-compliance case is an autonomous part of overall relationship, or they're inseparably linked? What is your forecast and maybe other issues relevant to the broader the DMA in 2025?
Thank you, Alice. I think so. This decision adopted by the Commission in April, for me, it's a sort of interim decision. sort of interim decision is this sort of long-term informal, because formally we are Article 5 DMA, where everything is self-executing and clear, but in practice nothing is really self-executing and clear between the Commission and Meta. I think the position of the two parties is clear. So we have Meta would like to continue as much as possible the business as usual. That's clear. Made a lot of money with target advertising, and that is the competitive advantage of Meta. On the other hand, we have the Commission that to open these markets, let's say, at least in their view, they have to, let's say, force Meta to, let's say, allow users to choose between personalized ads and non-personalized ads, let's say. This will be what the Commission would like. So I think at the end of the day, the two parties will settle. They will find a compromise. A compromise might be the ads break, let's say, that we discussed before, is a sort of compromise solution between the two. I don't know whether Meta will keep the monthly fee now that they are so low. Do they still make sense to them? In any case, no users have selected them. And if you have a third option, then they really don't make a lot of sense. So I don't know. These are just speculations, let's say. But I think at the end of the day, and that's the logic of the DMA. We're talking about ex ante regulation, so the parties needs to comply with the obligation. I think at the end the parties will settle. This decision, it's an interim. It shows on the side of the Commission that the DMA can bite, even if the non-compliance relates to 8 months, so a very short period of time. The amount of the fine is relatively small in comparison to the worldwide turnover of Meta. And I don't know, but I guess Meta appealed the decision to the General Court and later on to the Court of Justice. So I think the only positive thing of this decision is that we will have a ruling of the Court of Justice, probably in 5 years' time from now. And then in that ruling, the Court of Justice will have to clarify the meaning of this paragraph 150 from the German Meta platform case. So is it possible or not for platform to charge a fee? Yes or no? So we'll see what the Court of Justice will tell us. Probably it will be too late because in the meantime, Meta will have to comply in a different way, and it's already trying now to comply with the Commission request already by changing the concepts versus pay model. These are my guessing, let's say, but I'm not involved in the proceedings, so I don't know exactly what is going on behind the closed doors.
Thank you, Marco. Mikolaj?
It's also quite hard for me to predict what will happen with this decision. I do expect some sort of a settlement. I would be surprised if it ends up with an Article 9 application. But yes, but at least for an outsider, it's hard to see where exactly the Commission's ask is. What do they want beyond the availability of this less personalized ads option? I can see one problem which could become a similar or an even bigger problem than we've been seeing with hotels and Google's self-preferencing compliance measure, which was to basically end up prioritizing Booking and other intermediaries. So end business users have been very unhappy about that, which looks very embarrassing for the DMA and for the Commission. But the Commission, of course, refuses to acknowledge that. But what could happen here is a similar situation that if Meta is forced to sort of, make worse the advertising product, and for a long time we may see no real contestability, there will be no one to fill the void of that. you could see a backlash from business users who will say, well, this is not what this was meant to work like. It was the DMA was meant to help business users, European business users of Meta, right? And in the end, well, all it does is that we get contextual advertising, okay, non-skippable ads, but those things still don't allow, for example, smaller players to target locally, or to target, or especially not locally, but to target across the EU in a way that where they can make their small advertising budgets work, right? So if that happens, it could be another kind of a hotel-like scandal, but potentially bigger. I'm not sure the Commission sees that at all. They don't seem to think at all about the business users, even though this seems to be the justification for this whole decision. So yes, I do expect this to keep going through several iterations still. But maybe in the end they will actually accept what Meta is kind of doing now. So maybe I'm being overly pessimistic here. I don't know.
Many thanks, Mikolaj. I see Simonetta disagreeing, but let me just ask you to let me invite you, Mikolaj, just to clarify quickly the business users, Google, hotel, self-preferencing, and why it is scandalous in your view.
So what's the problem there? Yes. Well, the problem is that so hotels are complaining that the compliance measure that Google adopted, which was to remove their own sort of comparison feature from Google search, which linked directly to hotels, so directly to business users, because Google removed that as a, again, anti-self-preferencing compliance measure that effectively prioritized intermediaries whom hotels, the business users, have to pay. They don't need to pay Google, they need to pay Booking, they need to pay others. So they are obviously unhappy that they are being forcefully intermediated, where previously they were Google was the only intermediary and it didn't charge them. So they were not. So here you have an issue of business users being harmed in the name of contestability, at least in the short term. So I'm sure that there are many who will say that, oh, in the long term, it will all be fine somehow. But here's the problem. We see direct negative effects on business users and hypothetical promises that it will somehow work out in the end. And I worry that the same will happen here.
But this is according to Google's own study, or
no, not just the Google studies. So this is according to independent studies. I can send you some links. Yeah.
Okay, thank you very much, Simonetta.
So I'm not going into self-preferencing. Sorry, I mean, I don't think it's the topic of our discussion today. And of course, there are always business users complaining. And I also very often wonder how independent they are from the gatekeepers. And of course, it's also, we are stuck in specific business models. I mean, it's different to look beyond that. That this business model has brought us what we are experiencing now. So gatekeepers dictating the rules for everybody, and our democracy being under threat. So, I mean, of course, we could discuss it as well. So it's not that it's, I think it's really very important to think a little bit globally, I mean, global, holistically again, but it's also very important to enforce the provisions of the DMA religiously, as the EU legislator wants the Commission to do. So going back to that, I think I don't expect any settlement. Okay, I expect a strong enforcement by the Commission of this provision, also going forward. Because this provision in the AI age, and perhaps we can meet again, later, is going to be incredibly important. We have seen it already, an interpretation of this provision as applying to AI training data by Meta, by a German court, and interpreting the DMA as well. So I think this is, it's very important that we clarify this provision. It applies to Meta, but also to other gatekeepers. It applies to this type of combination of data, but also to other types of combination of data, think AI. So I don't want the Commission to settle. I want the Commission to enforce it properly and clarify the rule. Also because, and this is the last, I think it brings me back to what I said at the beginning, I think this is about end users' rights, not only because even business users have rights under the DMA. Okay, so but this is in this case is an end user's right to be presented with a specific choice, what we have been saying so far. And this is very important going forward. Also, if we want to combine it with rights under the GDPR. So I see judges already, there's been another court decision by a German judge already thinking, look, so private enforcement or private enforcement and the GDPR, but look, there is also something similar in the DMA. And these are the type of synergies that I would like to see going forward. Okay, so this is so no settlement, and also concerning these ad breaks. Well, to me, this is perhaps a degradation of user experience. Okay, so I'll demonstrate that's really something that you couldn't do without. So it's about condition of access, it's about user experience, about performance. Okay, so that will be the upcoming discussion that the Commission is going to have with Meta.
If I may, just one point to this. So I think one difficult axis of this conversation is this concept of necessity, and it goes to the issue of detriment under consent, and goes to the issue of what's even Article 30, Recital 36 and 37 of the DMA talk about those that there may be some degradations that is allowed, but it has to come from the fact that the service is less personalized. And I think there is a significant disagreement here where the gatekeepers, and I think quite reasonably, will say that you can't somehow remove the business aspect of the funding of a service from the service. The price at which a service is offered is its feature. So if the service is less personalized and then it just has to cost more in a different way, that comes from less personalization. So necessity can also be a business necessity. But I acknowledge that this is a very tricky issue. For the DMA doesn't have case law yet, but under the GDPR, the Bundeskartellamt decision from the Court of Justice dealt with that. I'm not sure in a fully coherent manner, but trying to actually sort of somehow remove business necessity from considerations of necessity, and then at the same time, the same judgment says, but if necessary, sometimes you may get an appropriate fee. So what kind of a necessity is that with appropriate fee if it's not necessary as part of providing a service? Like, we get two different necessities. I think this necessity talk will not leave us for a long time. You're muted.
Let me invite Marco and Simonetta. Many thanks, Mikolaj, to reflect, if you want to reflect on the latest point, or any other indeed. Otherwise, I propose to move forward for recommendations to students, do's and don'ts. You are established academics, you communicate with students continuously, even during the summer break, and you know a lot about, you observe a lot and you experience a lot of how different the students become. Maybe you can share some advice, some recommendations for them, implying that they will be within the DMA or competition law kind of ecosystem at some point soon. Marco, please.
Yeah, I can say that competition law, it's when we started, and I think you always, we started more or less at the same time working on these topics 20 years ago, was a very narrow field, very technocratic, very much linked to law and economics, no? Now it's very different. Okay, so what we see today, it's a case where we have a clear overlap between different legislation, competition law, the DMA, the GDPR, and we have not entered in the other data acts, let's say. So I think it's very important to have a more holistic view, let's say, of all these different EU legislation that affect in different ways, let's say, the digital landscape. This one first takeaway. And then the second one is that it's not only relevant anymore law and economics, but for students it's also important to specialize in law, economics, and technology. So you need to have a basic understanding of how the technology works, let's say, if you want to work in these areas. Let's say these are my two takeaways for students.
Thank you very much, Marco. Simonetta.
Well, I totally agree with Marco. That would have been my suggestions as well. And perhaps also, yeah, to be motivated to do the right thing, basically, because there are not so many people who understand also the societal dimensions of this field. As Marco said quite correctly, we moved for a very technocratic approach. And I started dealing with these topics 35 years ago. So I can tell you that it was really, it was still a Chicago school era. And somehow I had to take a PhD in economics to try to sort of understand what the industrial organization economists were saying, not being convinced by them at all, but it took a while. So I'm afraid that nowadays students perhaps have to all become data scientists or technologists to be able to confute the legal arguments, which is a little bit tiresome. So I would definitely look perhaps for increasingly dialogue and synergies among technologists, lawyers, economists. Really don't be afraid of asking also stupid questions, get into dialogue, okay? And do please use all the technological tools we have available, but in a sensible way. Also, generative AI can be great to try to understand many different technological aspects you don't understand. So I'm not at all against. I tell my students to use generative AI, but perhaps I tell them how they should use them. And yes, and don't give up, because it's a very, very challenging field. So you have to learn 24/7, basically. I don't know, Marco, Mikolaj, but that is my experience. So motivation is key, I would say.
Thank you very much, Simonetta. Mikolaj.
I agree with Marco and Simonetta on the point of that being interdisciplinary is important. Maybe it was slightly easier for me because I actually started as a computer programmer before I even studied law. But I think that we do live, partially thanks to generative AI, in an exciting moment for learning, because for kind of uncontroversial technical topics like in technology or basics of economics, LLMs can be great teachers if you're motivated and you want to learn. So actually the cost of learning may now be less than it was for us when we started. So I encouraged and also encourage not skipping economics, because I think economics is still important. We still need to pay for things and live together, work together. But that's one thing. The other thing I would say is I do encourage students to be to choose small topics, not necessarily to specialize all they do, but to try to become experts and also to publish. I noticed some PhD students who have been very active, for example, on LinkedIn and blogging and so on, building careers for themselves, even independently of whether what kind of postdocs they do and so on. And I think that has been working quite well. So not being afraid to be out there and to actually say what you think and make yourself known as an expert. I think that's good advice, especially for PhD students.
Mikolaj Barczentewicz, Simonetta Vezzoso, Marco Botta, thank you very much indeed for sharing your great ideas with all of us. It was a pleasure to see you.
Thank you.
Thank you all.
Thank you, Ali.
Bye-bye.
Thank you, Marco.